Now, AM 650 presents You and the Law, a comprehensive look at everything you need to know about the law. Now, here's Sterling Fox.
Well, hello and welcome to this edition of You and the Law here on AM 650. Nice to have you with us. Today we're going to focus on a category that most of us have probably heard mentioned perhaps dozens if not hundreds of times, but most of us, I would bet, are quite unsure as to what it exactly means. And we're talking about power of attorney. And to help us through all of this is David Hobbs from Hobbs Giroday in Vancouver. David, nice to see you again.
Nice to see you, Sterling.
Now, normally it's Hobbs and Giroday. Your buddy Ian Giroday is on vacation somewhere in the mountains of Peru this time around, so you're going to have to fly solo. You up for this?
I'm up for it. My partner dumped me, and it hurts, but I had an email from Quito, Ecuador this morning asking if everything was all right, and so I'll have to carry the load today, I guess.
Well, it's great to have you with us. Tell us a little bit about the firm, Hobbs Giroday, before we get into the business of power attorney. You are Vancouver estate litigation lawyers. What, for example, does that mean? And tell us about the firm.
Well, our offices are across from the courthouse in Vancouver, and a large part of our practice is estate litigation, which is dealing with disputes and problems and surrounding people's estates, their families, and those types of issues. We're a litigation firm or litigation boutique, but a large part of the practice relates to estate litigation.
Right, and by litigation, that means you're quite frequently seen across the street in the courthouse.
Quite frequently, been there a few times.
Right. Do most disputes involving wills and estates, David, get resolved before the court process, or is this one area of dispute that the courts seem to see more than many others?
Well, I would say most disputes don't make it into the courtroom for the trial, generally speaking. Some estate disputes, if there's a lot of emotion, a lot of anger, and people just can't come to grips with finding a solution, no matter how you try, then they end up in trials, and you end up with a judgment and maybe up in the Court of Appeal, following the Supreme Court trial. So some do. I would say probably if you want a percentage, I would say maybe 10% or something in that magnitude.
So the vast majority get resolved one way or another before the courtroom showdown.
Right, through negotiated settlements, through mediation, through dispute resolution processes, and that's more, I would say, more prevalent now than maybe it was 10, 20 years ago.
Now that work, the whole matter of litigating disputes between parties named in a will or involved in an estate, that all comes, of course, after someone is deceased. What we're going to talk about today happens long before any of those details that we've just discussed. We're talking about power of attorney on our program today, David. So let's get right back to square one. What, sir, is power of attorney?
Well, let's start with the word attorney.
Okay.
We in Canada, we don't normally refer to lawyers as attorney. We tend to think of that as more of a term they use in the United States.
And we watch a lot of American TV, so we're quite familiar with the term, right?
Exactly. And the word attorney means agent. It means a person who has been appointed to represent another person, and that other person has actually appointed this attorney or this agent. And so we use the word attorney regarding lawyers because they are our agents, but there are agents regarding legal matters. And so in the United States, you'll see attorney at law.
Right, of course. And
it could say agent at law, but the word attorney is used. Our real estate agent.
Right.
Could call him our real estate attorney. It's a person we appoint for purposes of a real estate transaction, to list our house, to sell our house, and to represent us in all of that. And that's another example of an agency. And really the word attorney and the word agent are almost synonymous. Your attorney is your agent for some purpose. Power of attorney is now referring to the instrument that or document that appoints a person to be to have general power of attorney or to have some restricted powers. And we can talk about enduring power of attorney versus general power of attorney and so on. But it's a person I've appointed to be my agent.
And why does someone appoint a person to be their agent, or why does someone delegate this power of attorney? What generally is the reason for it, David?
Well, you commonly see it as people are estate planning and they're thinking that they want to have a person who can make financial decisions for them regarding their assets, maybe as they age or if their health fails. Yeah, but it can also be for reasons of travel. I go away on a trip, I have an accident, I'm not killed, but I need someone to help look after my affairs. And so I appoint some trusted person to be my right-hand man, so to speak, if I'm not available or able to deal with financial matters.
So typically, though, is a power of attorney something that a person considers for a specific reason? It's not something, well, I'm 54 now, so I should find somebody in my life to delegate power of attorney to. It's not that kind of thing, is it?
No, and to be very, very precise, power of attorney refers to the actual document. It's the piece of paper. Lawyers use the word instrument, or they say the instrument.
Right.
And so when we say power of attorney, we're talking about the actual instrument that appoints a person to be my attorney, and it sets out their powers, i.e. their authority. And the most common garden variety type that we normally see is what we call a general power of attorney.
Right.
And it gives the person the power to do anything you can do. It's as if they're you in terms of your financial affairs and so on.
Now, if I delegate someone, what's the legal word? Do you grant someone power of attorney?
That's the technical legal way we view it. You're making a grant.
Okay, so if I grant someone power of attorney in my life, but I'm still present and quite capable of looking after my affairs, is that person kind of my backup on standby with no real role until I act in such a way that they're going to need to stand in on my behalf?
Well, if you've executed the power of attorney, and if your attorney has a copy of it or the original of the power of attorney, then they can go out and effect transactions on your behalf that you might not even know that they're doing.
Oh.
That's not the expectation.
So it becomes immediate, though.
Yeah, once you sign that document and create it, you've empowered that person to be your agent.
So this is not something one does flippantly, ever.
No, and the issue about having the original of the document or copies of it or who has it and so on, but if you sign it and circulate it, then it's in play, if I can put it that way.
Okay.
That would not necessarily be the expectation, the discussion. I might appoint my son or daughter as my attorney and sign the power of attorney, and then we might put it in my safety deposit box.
Sure, exactly.
And they know where it is. Or I might say, use this when I'm on a trip, and so on. But the reality of it is it exists, the appointment's been made, the power's there, and if they can show that document to a third party, they'll be able to engage in a transaction.
You're listening to You and the Law here on AM 650. Our guest is David Hobbs from Hobbs Giroday in Vancouver. HobbsGiroday.com is the website, and all sorts of terrific information about all of the activities of the firm. But back to power of attorney here, David. Is it possible to grant power of attorney to more than one person?
Definitely, you can have joint attorneys, which means that they have to act jointly, which means they would act in unison. They would have to agree with each other. You can have powers of attorney that give specific types of powers to one person and other areas of responsibility to another person.
Oh, really? So you can split up the powers if you want?
Yeah, you can create ways of resolving conflicts between the attorneys by having some democratic process whereby they make decisions as if they were sitting as a board of directors of a company, and,
right.
and the majority would rule. They're not things you commonly see, but you can form that power of attorney almost any way you wish in terms of who, scope of power, how many, and so on. But it would all be set out in the power of attorney in the instrument.
Now, typically, we've talked about the reasons that some people give for going to the power of attorney point in their lives, but I think the popular perception is that this is an instrument that people employ or grant to delegated individuals when they're threatened by ill health or diminishing mental capacity. I think that's a fairly popular perception of why anyone would go to this power of attorney thing in the first place.
Yeah, I would agree that it's put in place. It's typically they're signed and there's no active intention that they be used at that point in time. It's about if and when such and such happens, and so if a person becomes ill or is unable to get out and they need help affecting transactions, dealing with the bank, transferring property, selling cars, all these sorts of things.
Right.
It's the breadth of it is a bit pervasive, because with a power of attorney you can do things like change the designation of a beneficiary in a life insurance policy.
Without the person for whom the policy is named having any say in it?
No, well, yes. In the way you pose that question, the answer is yes. I can go to the life insurance company, produce my power of attorney, and say that we'd now like so and so to be the beneficiary of the life insurance policy.
Oh boy. So there is, and I'm looking at this perhaps through my cynical filter at the moment, but there is room in this whole process of granting power of attorney for individuals who are less than scrupulous to misbehave and, take advantage of people who have placed their trust, perhaps wrongly, in them.
Right, and what you see and what we see is that people pass away or they're ill, they're elderly, and there's one member of the family or the group that has had the power of attorney, but no one knew the transactions that they were putting in place, the changes that they were implementing using the power of attorney. And when the estate is then examined, there's an expectation that the deceased still owns their car or still owns their house,
right,
or and so on. But then there's a discovery that the power of attorney has been used and the lay of the land has been altered. And there's no reason why the others would know about it, because it's not a process where you're announcing anything or disclosing anything. You're just out dealing with a bank or an insurance company or selling an asset. And this stuff is all hidden until it surfaces.
Well, now, your business at Hobbs Giroday is estate litigation, so I would assume that, given the description of nefarious activities with the power of attorney, that from time to time, in a dispute over a will and the outcome of an estate or the division of an estate, somebody's been found to be, monkeying around with their power of attorney, flexing their muscles a little too vigorously, perhaps. Thus, Hobbs Giroday gets called in to level the playing field again.
Yes, I think of one situation we saw where there were many brothers, and one of the brothers was a professional person. He was a well-to-do person. He had a good income and so on. And one of his brothers, of the many brothers, had a power of attorney and was very close to, had a close relationship, and was, for all appearances, was being looked after by this professional fellow. Lent money, pay for things, trips, and so on. And of course, the poor gentleman had cancer. He died, and then the rest of the family became aware of the status of his estate, and this whole fact that the one brother had been using this power of attorney in the way that he had surfaced. And then, of course, there's a tremendous disharmony and an upset.
Well, I guess there'd be an expectation that X amount of dollars would be left for division among the rest of the siblings, and lo and behold, the dollar figure was well below what everyone else expected, and they discovered that the dollar figure was low because the guy with the power of attorney had spent it all.
Well, that's one way of looking at it, and people do, and money is the root of all evil, but I think, moreover, people are upset to learn that someone has been abusing or manipulating someone else.
That's true.
It's very offensive to them.
Yes, yeah.
And that evokes a lot of emotion and reaction and upset, in addition to the fact that an estate is been diverted in some direction.
I need to take a quick break here, but just before we do, in terms of my fundamental understanding of the concept of power of attorney, another part of the whole wills and estates process is the executor, a trusted person that you appoint to, take care of your affairs after you're gone. Can a person with power of attorney also be an executor?
They can be both. They would be named as attorney in the power of attorney, and they would be named as executor in the will.
So separate appointments.
Separate appointments. I think the most important thing to understand is a will doesn't take effect until the will maker passes away.
Right.
And then the appointment that's set out in the will triggers. It comes alive, and the executor now exists. The power of attorney ceases to exist because powers of attorney are only effective while the person who's appointed the attorney is alive.
Of course. Okay.
Yeah. So, but it would be typical to trust someone to be your attorney and to trust them to be named as the executor in your will as well.
All right. Well, we'll talk lots more about power of attorney. This is fascinating stuff, and David Hobbs is the guy to take us all through it. Hobbs Giroday is the firm. They are Vancouver Estates litigation lawyers downtown, and we'll be back with lots more here on You and the Law on AM 650.
This is You and the Law. There's more of the show still ahead on AM 650.